Yes, Mr. Hussain.
My Lords, in answer to the Master Rolls question to me, envisage tens of thousands of returns. Bundle 4, Common Bundle 4, tab 57, page 1289.
Sorry, I need page 1289.
Page 1289. We accept that transfers are subject to Rwandan consent, but...
I'm so sorry, I'm behind too. We're struggling to catch up, Mr. Hussain. So, 1289.
Page 1289.
In which bundle?
4.
So this is a speech by
the Prime Minister
in April 22. Yeah.
So that's sort of the envisaged numbers, though I of course accept that as the Divisional Court observed at paragraph 65.
Sorry, I haven't. Sorry, Mr. Hussain, you are going to need just to take us along with you. Where do we find on page 1289 that figure?
At the very bottom. Thank you, Mr. Kaufman.
And also at the very bottom of mine.
1290.
Oh.
So 1290.
Still don't get
The pre-penultimate paragraph.
Sorry, which paragraph? What does the paragraph begin with? Which words?
The deal.
The deal.
The
Is uncapped. Tens of thousands in the years ahead.
Yes.
Well, that's hardly. I mean, that's in the years ahead. How many years?
I think it's
Sorry.
5 years.
Well,
But I think I did say it was envisaged.
yes.
And I also accept, I was going on to say, I also accept that transfers are subject to Rwandan consent. I accept that.
Yes.
So it's not part of my case that my clients will be transferred with tens of thousands of others. That's not my case. However, the prior consent of Rwanda is not an answer, contrary to what the Divisional Court thought at paragraph 65, because the issues with the system are qualitative as well as quantitative. That's my answer to my Lord, the Master of the Rolls. The Vice President's piece of homework for me, can we hand up a note later in the afternoon? Would you mind, my Lord, if I do that? Thank you. So then can I please rattle on? I had finished addressing, well, I was on the inadequacy of the asylum process, our skeleton, paragraph 20. Again, if I may, I'm going to leave that as it stands.
Yes.
Then can I please move on to our skeleton at paragraphs 21 to 22. This is errors in the approach to evidence. I just want to make 6 points if I can. One.
Sorry.
What's wrong, my lord?
I know you're worried about time. You must these days.
I think I said to you, my lord, that was a recurring theme in every hearing that there'd ever been in this case.
Right now, you were.
I was in my skeleton.
Yes.
At paragraph 20.
Yes.
I don't want to say anything more.
No, I got that bit.
I'm now on my
6 points. Right.
So I'm going to my third point of my 6 points. Approach to evidence, and it's our skeleton 21 to 22.
Yeah.
And I want to, under that head, I just want to say 6 things, if I may. One, the court did not properly consider the respective status and quality of the evidence, on the one hand, from the government of Rwanda, and on the other, the UNHCR, both as a matter of form and substance. There was no consideration by the court that on the Secretary's own case, the material, I'm going to call it material, from Rwanda was partisan. the material was a response, which you've seen, page 1333, 467, unsigned, unauthored. A table at page 1387, which you've seen, 476, from the official at the MOJ, unsigned, with the name redacted. An email, which you haven't seen, I don't want to take you to it, 19th of July, page 1439, 479, unsigned, redacted, and then a statement which you've seen, 2nd of July, page 1341, 468, signed, but no statement of truth. Mr. Pobroy reminded me that the paragraph I took you to at his invitation indicated there was a sworn affidavit provided by a very senior Rwandan official, I think the Prosecutor General, in the extradition case. And it's one thing for the Secretary of State to rely on these materials for the purposes of negotiating the MOU. It's another thing to rely on these materials to defend her position in court.
Well, I'm just looking at the statement of the government of Rwanda at page 1341.
Yes.
Was that put in on behalf of a party to these proceedings as a witness statement?
No, I don't think it was. It doesn't have a statement of truth. It is...
It is signed by the minister.
It's exhibited to Mr. Armstrong as Exhibit 59.
It is signed by the minister.
It's signed.
Yes.
No, by an official. It's not
So it's signed by the Minima minister, Mary Solange Kaisir.
No, you're right. Yes. There is no statement of truth.
No.
We respectfully submit. And you've seen...
But does there have to be to an exhibit of this kind?
It's a matter that goes to weight, we say. I have the point. I'm not going to press it.
Mr. Hussain, just don't go so fast that you tell us things that aren't reliable. It's really important that everything you tell us.
Yeah, I hope that's the first error.
Yeah, I am really concerned for you to go slowly enough that we can get it down and we can understand fully your submissions. I really am.
I was very anxious that I've got I'm against the clock at 4 o'clock.
Yes.
If I go slightly over, can I shave that time off my reply? Would your lordships be prepared?
I'm sure there is a little bit of flexibility available, but the trouble is, Mr. Hussain, if everybody does the same, then we're in a good deal of difficulty.
Yes.
So I'm sure you'll be able to develop your submissions in the time available, and if necessary, please give us references which we can look at without necessarily taking us to everything.
Thank you, my lord. I'm very grateful.
Well, and if one goes on, the Master of the Rolls asked about the statement that you have that's on your screen at 1349. Mm. There is an explanation of how that came into being in Armstrong 1, paragraph 89, Common Documents Bundle number 3, page 1046.
I'm grateful to Sir James as ever. My lords, the second point I was going to make, if I may, is that the material provided was often internally contradictory or inconsistent with other incontrovertible evidence. The easiest way to do this, if I may, is just to give you a reference to the UNHCR's observations, paragraph 19 in this court. There were claims like, I'm not going to give you references, just give you a very brief description, claims that the officials had received training by the IOM, when the IOM, the International Organization for Migration, when they're contacted by Mr. Botnick in his third statement, they say, we have never offered training, and there's a formal letter to that effect. The third point I wanted to make is that UNHCR's evidence in this case was very detailed, carefully prepared, and commanded weight for the reasons we've set out. Our skeleton, paragraph 22 and 41, and UNHCR's observations in this court at paragraph 7, 16, and 19. And this was against a background where the Secretary of State recognised the undoubted expertise of the UNHCR, recognised it would be useful to compare and contrast their assessment with that of the government. That's at page 1211, 449, page 1211. And yet they never do that. The fourth point, and UNHCR's observations really, it's very detailed. You'll have seen about the care with which the material was prepared, how many people were consulted. I think over about 5 agencies, Brussels, Geneva, London, Kigali, and the Horn. 5 agencies, extremely carefully prepared, and absolutely bang centre in their expertise. What is RSD about? What do you need? They are a standard-setting UN organ on that question, and they are giving you, in their observations below, a set of criteria reference to ex-con materials or the UNHCR handbook, and explaining how Rwanda does not comply. 15 areas, 2 of which are condescended to by the court, apparently arbitrarily. Fourth point I was going to make is that the Secretary of State seeks to argue in her skeleton at paragraph 12 that the court conducted its own Ilias examination and considered that it was discharged on the basis of the 9th of May assessments and the MOU. But the problem with that is that those assessments excluded deliberately, we say, that's a description, it's not meant to be pejorative, deliberately excluded the UNHCR from their assessment of the RSD, contrary, we say, to the Ilias duty to seek out information proactively. And what is really important, the fifth point I wanted to make here, is to invite you to look at Botnik 2, paragraphs 131 to 141. Botnik 2, 131 to 141, that is page 1721 to 1723, 596. And that gives you a history of the UNHCR's engagement, or lack of it, with the MOU and note verbal and the assessment, and why that was so. They weren't told. And so, what he said by way of evidence, and the submission was made by Sir James below, in accordance with this evidence, is unfounded. The evidence from Mr. Armstrong is that the MOU reacted, in effect, to the UNHCR's concerns. He says, and this is page 1017, paragraph 16.2, 326, he says, we discussed any areas of the current Rwandan process that had been flagged to the UK as weaker areas of the current asylum system by, for example, the UNHCR. Well, you never, at the Secretary of State, never at any point, until after never at any point sought out UNHCR's views as to the viability of this arrangement. And that's simply not available. If you look at Boltonic, you will see that that simply just is not available to Secretary of State on the timeline. That's all I wanted to say about the third error. The fourth error under Ilias is the interview notes. Our skeleton that paragraph 23. I'm not going to say anything orally about that, if I may. I'll leave 23 as it is. The fifth error concerns certification. Paragraph 24. I do want to say three things about this. We get the Divisional Court's view about certification at 179 of their judgment, where in one parenthetical clause they say that there's nothing in the objective material in the generic grounds to establish any illegality in relation to admissibility decisions or decisions refusing human rights claims and certifying the claims as clearly unfounded. And your lordships are well familiar with the test. It's a very low test. The case has to be bound to fail. They considered that their generic conclusions would impact the question of certification in the future. We get that from 285 of the Divisional Court. Last three lines. So 285, this is the quashing of the certificate of one of my clients, AAA. The decision will be quashed. Sorry, no, it's AAM. This is AAM, my fourth appellant. The decision will be quashed. The defendant will have to consider the human rights claim and the question of certification in light of all the relevant material, including, if considered appropriate, the court's conclusions on the UNHCR evidence. And this is in circumstances where they say at 395.
So, para 395.
Para 395. I'm only giving you para references to the court.
Good.
It's also right to note for the future that the generic issues raised by the claimants as to why relocation to Rwanda would be unlawful have now been determined by this court, subject to appeal, subject to any new information.
Sorry, what was the paragraph reference for that?
395.
Thank you.
The Secretary of State says that we've somehow misunderstood the first reference I gave you, 179. This is her skeleton at 18, paragraph 18, because the Divisional Court didn't find granted permission to apply for judicial review on this point. Our response to that is, well, quite. And this is very important for the future. It's fundamental. Because your lordships are aware, these cases are intended to go, unless they're completely hopeless, to the fact-finding body, the tribunal. The reason they've come this way is because the removal directions were set before there were human rights decisions and certification decisions. So we challenged certification by way of amendment and re-amendment to the grounds. But
I'm sorry, I got completely lost. You're taking it so quickly. What's your point?
The point is that our primary cases, grounds 1, 3, and 4, are made out on the normal basis. They've made out. We've established illegality. Our secondary argument, our fallback argument, is that those arguments would not be bound to fail before the tribunal. The Divisional Court have said, yes, they would be. In that one parenthetical clause, without consideration of the advantages that a fact-finding tribunal enjoys, the ability to cross-examine the Secretary of State's witnesses, applications for cross-examine having been refused in our case, and so forth. So if your lordships are of the view that my grounds 1, 3, and 4 are not bound to fail, your lordship may not be persuaded that they're laid out, but not bound to fail. You should say that, because that will enable, in the future, certification to enable these cases where there are human rights decisions to go to the statute.
What's your particular point about the grant of judicial permission?
That's their point.
By the Divisional Court, that is inconsistent with the finding that it's bound to fail.
Absolutely. Yes, thank you. Sorry, you put it in a sentence when I was labouring the point. Apologies. Next point on...
Sorry, Mr. Hussain, just for I know we've looked at it, but I want to tie this up. remind me that the subclause in which paragraph of the judgment, so I have a note of it next to the two that you've just given us. 285 and
I've missed it. It's 285 and 395.
so those are the two.
Exactly.
That's it. Okay.
No, sorry, 179 is the key.
Oh well, that's
sorry. I'm so sorry.
That's what I wanted.
179 is where that's the parenthesis where they say the generic conclusions mean that the clearly unfounded challenge also fails.
Yes, I see. Okay.
179. Sorry if I'm.
Are you aware? And maybe it's more a question for the Secretary of State, but are you aware of any cases where the Secretary of State has made a human rights decision without certifying?
No. She always certifies. So it's very important. And that's our skeleton at 24.
And at the risk, I know you're short of time, those behind you might look up in, I think it's in NA Sudan, that there was some discussion by this court of the unsatisfactoriness of having to decide factual questions where the actual question was based on certification.
Absolutely.
Perhaps you can get us the reference, but not that.
Yeah, the quid pro quo is that the Secretary of State has got to have an incredibly powerful case. Our case has to be hopeless. So my submissions to you about Israel and Rwanda, in-country reform law, independence of the judiciary, have to be hopeless at the process duty stage for 179 parenthesis to be upheld. And the final point I was going to make on Ilias, if I may please, is the idea that it's all very well because you're not going to be returned anyway. And that we see that in the Secretary skeleton at paragraph 8, footnotes 11 and 12. We say that is not open to the Secretary of State to advance because it was no part of the Divisional Court's approach. There is no respondent's notice. It's a thoroughly bad point, if I may say so.
I don't even know what the point is at the moment.
The point is that...
Well, I'm just going to read 11 and 12.
Footnote 11 and 12 and 8 of the Secretary of State. Paragraph.
Yes, I see.
If you see the point, that our response is that forms no part of the court's judgment below. There's no respondent's notice. And therefore the Secretary should not be permitted to advance it.
Was there evidence of it before the court below?
Sorry, yes, it was. Yes. It was contested, but they just don't say anything about it. Yes. It would retract a respondent's notice now.
Yes. Okay.
An additional reason why the judgment should be upheld. You haven't got one. I'm prepared to if you like, address you on the merits on it, but I'm going to leave it to reply given time. But my primary position is this is not open to run. We'll see what Sir James says about that, and I'll come back to that. In short, the evidence was wildly inconsistent on this point. Wasn't in the net verbal or anything.
What's the evidence about whether you return people whose claims are refused?
Yes. Yep. Ground 2, so I must resist the temptation of getting rid of myself. Ground 2 is Tameside, our skeletons 29 to 33. 4 points, if I may. First point, I've already made temporal focus, which the court seemed to ignore. Paragraph 46, when it said the information has expanded. Paragraph 47, all this information was covered. Second point, there are two operative decisions here. One set of decisions in the individual cases, but the other operative date is 9th of May 2022, because that is the date when the general assessment, which is still live, it's still the document that decision makers are expected to go to, it is published. And we say that it's very clear that at that time the assessment was Tameside deficient. Third point we make, standing back by 9th May, and all the more so for 5th of July, Secretary of State had been informed of very serious concerns by the UNHCR as to how matters operated on the ground. The only rational response, we say, we put it that high, was to pause and investigate. She downplayed those concerns that had been pressed on. That's the third point. The fourth point, I'm just going to give you references, if I may, to the Campaigns Against Armed Trade case, which we've cited in our skeleton on this point. And that the reference is Volume 20, Core Authorities, 46, page 1610. That's the case. And then I derive 3 propositions from that, if I may. One, the relevance of, it upholds the relevance of past breaches of IHL in that case to the future risk of IHL breach.
What does IHL stand for?
International Humanitarian Law. And the reference there, the key paragraph is para 138, page 1646. Second proposition, it establishes, we say, is the need for proper engagement and assessment of material showing past breaches. No need for adjudication on each and every incident. My Lord Chief Justice will recall the issue. And the paragraph numbers there are 98 submissions of Mr. Chamberlain. If I can say as he then was, I remember the Vice President once said to me, that's surplusage to say as someone then was. But Mr. Chamberlain, paragraph 98, page 1638, and paragraph that 165, the court's conclusion, page 1653. Third proposition I derive from this judgment is that the efficacy of assurances given at a high level by the kingdom and training are no answer without such a proper assessment of what's happened in the past. And it's paragraph 144, page 1647. So James will no doubt point to points of distinction. We say those are not material points. The conclusion was a Tameside breach in, your Lordship will be aware, the very light touch judicial review area where executive expertise was very properly and understandably claimed. We are a fortiori. We have the Article 3 question, where that was for the court, not the Secretary of State. Judicial review is not light touch, but concerns fundamental rights adjudication of those within the jurisdiction. And the principal issue, which I will develop in a moment, is about capacity of, I don't mean numerical capacity, I mean in a qualitative sense, capacity of Rwandans to meet the assurances, not simply trust. That's all I wanted to say about Tameside, if I may. And then Surin is our ground 3. Our skeleton at 34 to 35. I want to make 5 points. 1, our skeleton 37 to 38. The court neither asked nor decided the serving question for itself as regards whether the Rwandan system, the process, was safe and reliable. It is common ground it needed to. The court thought it did. See its consequentials judgment, paras 17 to 18, page 57, volume 1, common, tab 2.
Sorry, I need that reference again.
Common 1, tab 2, page 57.
Of what?
Common 1, common bundle 1.
What page?
57.
Page 57. Thank you.
57. So the court thought it did, and the Secretary of State
thought it did what?
asked the serving question for itself. I'm so sorry.
Page 57.
157. My note is wrong. Thank you.
157. That is the judgment of the Divisional Court on costs. At which paragraph do you want?
17 to 18. I'm so sorry, Michael. Do forgive me.
Yes, I mean, it's not, this bit is not on costs, this bit is on permission to appeal.
That's right.
Consequential. Not yes.
Yes.
Sorry, did you say?
And in short, Lord Justice Lewis simply says, well, you've misread the judgment, and taken little bits and pieces out of context.
He says, I've taken one sentence out of context.
Yeah.
And the point I'm trying to make is that they're defending that the idea that they did that they asked the question for itself. That's the first point.
Well, I mean, the court perception is that it did decide this serving question.
Yes. We say no, it's not just one sentence.
Is that a linguistic submission that on a proper interpretation of the judgment they didn't, or what?
Absolutely, yes. Wittgenstein would agree. There's a judgment of Lord Hoffman's about how when judges give their judgments, then what they mean is a matter of objective interpretation.
Yeah. But your straightforward point is that they really treated this as if it were a judicial review question.
They did, yes.
That's your submission.
Absolutely.
Yeah.
In our Scouser, my lord, explains why we say that. The first reason we give is at paragraph 37, where they say it's not necessary for us to address every such point, those points being the points that the UNHCR had raised. I mean, the pre-penultimate line of paragraph 37. They pick two out of UNHCR's concerns and deal with them. That's, we say, a very cursory analysis. It tends against the idea that they were rolling their proverbial sleeves up and deciding the question for themselves. And then, as a matter of language, at 38, we have given many references where they use the language of entitlement, which suggests a range of responses for the Secretary of State, rather than asking whether the Secretary of State was right to conclude as she did, because of expertise, cogency of evidence, and so forth. We've given you lots of references there. But perhaps the most telling are the ones at 68. Paragraph 68, yes. Where they say, and you may recall, I've shown you it already in the context of Israel, Rwanda, that the Secretary of State's approach was permissible and there was no error of law. That's the clearest possible indication that they're asking a rationality type question, rather than a question for themselves.
Well, it depends what they meant by no error of law.
Our submission is, the court had to decide Article 3 issue for itself. It did not, and therefore the fact that the Secretary had not erred in law was not dispositive of the task before it. If it's applying conventional judicial review, it would be.
Do you disagree with the concept that what the court ought to be deciding was whether there were substantial grounds for thinking there was a real risk of Article 3 breaches?
I concur.
That's your submission.
Yes. Yes. And interestingly, I'll come to it in a minute. They do that on one part of the case. They don't on the other. I'll show you that in a minute. But just can I stay with the language, please? You have my submission on paragraph 6. You also have it in 71, where they say the Secretary of State's position cannot be undermined by the UNHCR evidence, in parenthesis, to the extent that it is legally flawed. That's the clearest possible indication that they're not asking the question my Lord the Master Rolls put to me.
I need the paragraph number. Because
I thought I gave it to you, 71.
Yeah, no, I'm sure you gave it. I was just noting down.
71. And that is in our skeleton squarely. In paragraph 38, the Secretary of State does not respond to that. Her response to the previous very clear indication of an inapt approach, wrong approach, more than inapt. 68, the last sentence of 68, Secretary of State says there, this is Israel, permissible approach, it doesn't disclose error of law. Secretary of State says at paragraph 26, Roman 2, that, well, this necessarily involved rationality. Well, why on earth is that right? It's not as if Tameside is the only show in town. Absolutely not. Why couldn't the court say, it would have been very easy for the court to have said, we ourselves do not think that this has any weight. And we assign it no weight. Instead, they go through the medium of the Secretary of State and ask whether she erred in law. That's classic judicial review. So Secretary of State seeks to answer that by saying, well, this necessarily involved a rationality question. Not at all in our submission. But there's no answer at all to the point at 71, where they say, it, at about 6 or 7 lines up from the end of the paragraph, we must decide whether on the totality of the evidence, the Home Secretary's opinion is undermined to the extent it can be said to be legally flawed. And when they do reach any conclusion on stirring, it's at 58, paragraph 58, where they say the Secretary of State was permitted rationally to conclude that Rwanda was safe. That's at 58. The Secretary of State defends this by saying, well, part of our challenge was rationality. We're true, we advanced the rationality challenge, but we also had a discrete Article 3 challenge.
But there's a heading at about paragraph 156, rationality challenge.
At 156, did you say?
Somewhere like that in the judgment.
165.
165.
That's Mr. Gill. That's not me.
Mm-hmm. Okay.
So, but I should make it clear, we challenged on conventional rationality grounds the certification of Rwanda as safe under the rules. There was that challenge there, but there was also a very clear Article 3 challenge. And it's on the Article 3 challenge.
In fact, if you're relying on virtually all the same points for both the rationality challenge and
Yes.
the Article 3 challenge.
Yes.
So really,
the rationality challenge doesn't really matter.
Well, it was broader because it also encompassed refugee convention issues. The answer, you could say...
Well, one of the oddities is that some refugee convention issues appear to be regarded as Article 3 issues. If you look at Ilias, I think it's Ilias,
yes,
the risk of refoulement
yes,
is simply treated as an Article 3 issue, although it's a refugee convention concept.
It's broader. Article 3 is broader. Chahal says that in terms. The genesis, Article 3 does not have an extraterritorial prohibition on its face. It was read in Suring. That's why we all call it the Suring issue.
Yeah.
Chahal says it's not subject to national security, and that's where the court says in terms it's broader than the Refugee Convention, because Refugee Convention Article 33 is qualified. But the point here is that we were running a number of challenges. The court did not address properly our Article 3 challenge because it didn't ask that question for itself. And the contrast is, I was careful to say orally that it didn't ask the Suring question as regards the refugee determination process, because it appeared to ask the correct question about conditions and protests. If you look at 674 to 77, I accept that there the court did roll up its proverbial sleeves. And that the contrast is extreme, we say, between what it did there. So what happens if you protest? Will you suffer an Article 3 risk? And the other passages I showed.
Just give me the, what's
the 74 to 77.
So the way the judgment was structured was to look first at the adequacy of the asylum system, and we have your submissions on why that was legally flawed. Then the judgment dealt fairly summarily with the Gillick issue.
Absolutely.
Next, it looked at what I've taken the court to understand to be the extra Article 3 issues, beyond the adequacy of the asylum system and refoulement and so on. And there they did ask the correct Suring question.
I accept.
I see.
And but it's a point that avails me because there's such a striking contrast. They're not asking about in 73 about the whether or not Secretary of State's approach disclosed an error of law. They're not saying there was she entitled to conclude as she did. Not at all. Striking contrast. The second point I made, we make in our skeleton, is that paragraph 39, where we say, again, the court misunderstood UNHCR's evidence about its position. That misunderstanding remained material. There was a reference in paragraph 70 of the judgment, which may have suggested that it was the misunderstanding, as we call it, was immaterial, because they say, be that as it may, fourth line from the end. But they then say, next sentence, the question is, notwithstanding the opinion UNHCR has now expressed. So it remains live, and over the page, I think this isn't in any of this, it's not in our skeleton, it's not in the observations. They again say that. In the middle of the paragraph, 71, the opinion of the UNHCR now expressed on instructions from Mr. Botnick carries no overriding weight. Well, it wasn't now expressed on instructions, and you've got chapter and verse. I'm not going to do anything except give you references, if I may. And perhaps the best place is UNHCR obs in this court, paragraph 6 and 23.1.
Sorry.
Observations, paragraph 6 and paragraph 23.1, our skeleton, paragraph 39. your Lordship may recall, the Vice President may recall last month I made the point that at its best, this was the point about semantics. UNHCR were consistently talking about rights. This is the correlative duty on Rwanda. If there's a real risk of refoulement as a matter of individual right, it necessarily follows, because these are legal rights, not moral rights, that there is a breach of duty. These are Haffeldian legal rights. So, semantic wordplay at best, with very great respect, we say. Our skeleton at paragraph 40 makes the point that there wasn't any contrast between the views expressed in this litigation as against July 2020. The focus in that report was on prima facie determination, large scale. That was made clear at the time. As regards individual decision making, concern was expressed even then about obstacles. So the issue isn't, well, everything was fine then. What's changed? Not at all. The difference is, the point is that then those observations were directed at apples. We are now in oranges territory. And as regards oranges, even then they said there are problems. The third point I wanted to make is at paragraph 41. This is also covered in Ilias, so I'm not going to say anything about that except to invite attention to paragraph 41. And this is something that the UNHCR also address, as you might understand, at some length, in their observations, paragraphs 14 to 21. The fourth point I wanted to make about Suring is at paragraph 42 of our skeleton. And the short points are, it is very clear that any kind of protest is rigorously clamped down upon. We've cited Mr. Titchener and the FCDO's review at the end of paragraph 44. 3 of 6 of my clients have expressed dissent in detention. There's a real risk of dissent, we say, against conditions in a state transfer to which they are extremely opposed and fearful of. All say they're very scared. NSK's statement is concerning. He says he was howling and crying. He felt suicidal when he was put on the plane. NSK is the individual who obtained the Rule 39 measure. The note verbal, paragraph 17, of course, says that you can lodge complaints, but it doesn't tell you how they will be treated. The fifth point I wanted to make, it is again about certification. The Secretary of State says at paragraph 37 here, this time not saying, oddly, well, you got permission on this ground. This time she says, it's not material to the generic assessment. I've already shown you why it is. See Divisional Court, paragraph 285 and 395. That's all I wanted to say on Surrey. Ground 4, then, is Ottman. And I wanted to make 7 points here. The first, I've already made submissions on in the context of Suring. The first is they didn't ask the question, the Article 3 question themselves. Ottman is Suring applied to assurances. And we have cited at paragraph 47 of our skeleton the Divisional Court at 64. The question was, was the Secretary entitled to rely on the assurance? Another phraseology, I don't want to be prescriptive, would have been she was correct to, she was right to, given the weight that she can command. Our conclusion is, etc. No, the court goes through the medium of the Secretary of State, suggesting classic judicial review approach. The second point, and it's a separate point, not the two sides of the same coin, it's obviously related, is that we say that the court afforded excessive deference to the Secretary of State by proceeding on the basis that it shouldn't go behind her assessment without compelling evidence to the contrary.
Can I ask you,
yes,
in your submission, what, if any, deference is to be accorded to an assurance given by one government to another government, by this court or by the Secretary of State?
Yes. So,
and therefore,
my Lord, of course, I would accept that on the question of whether or not the government can be trusted, that is an area on which the executive is entitled to expect respect in recognition of its institutional expertise. We accept that. That doesn't mean it's immune from judicial review. If there are material errors, then its decision to that effect may be quashed. So, for example, if none of the witnesses address the question of the independence of the judiciary or the fact that Rwanda has not cooperated with international mechanisms, that those may be grounds for quashing the Secretary of State's decision to that effect. And we say those grounds exist here. But by far the more important consideration in this case was not, are they acting in good faith, but can they deliver? Because this was an assurance about changing a system. And who was the body that had expertise as regards that system, whether it could be changed, how long it would take, what it would need? It's the UNHCR. And the court erred in failing to give any recognition to that. It effectively proceeded. There was some condescension to the practicalities at 65, but it was inadequate, as I'll show you, I hope. But it proceeded as if the question of expertise, quite good faith, was the decisive issue.
So you can understand what you're saying. You're saying that while the government can expect respect for its peculiar institutional competence in judging the good faith of another government,
yes,
it's not entitled to expect any deference for its assessment of the ability of the other government to deliver on good faith assurances?
Well, if it's a torture, I would say that's not my position at all, for two reasons. One, if the assurance concerns something which the state can do, then there isn't a material distinction between can you trust them and can they actually do it. So we won't torture. That's something you can trust Jordan on in Ottoman, because the state can simply desist from doing it. The Secretary of State could, in theory, command respect for her views in a situation such as this, where the assurance is much more complex, concerns the adaptation of a whole system, where there are issues of resources, capacity, training, structural problems like the independence of the judiciary. She could, if there was detailed, proper engagement with those issues. But there isn't here. Indeed, in our skeleton at paragraph 41, we cite an extract where the government officials in terms say that the UNHCR is the expert body. We've got no way of verifying what the Rwandans are telling us, other than through them. It would be a good idea to compare and contrast what the UNHCR and the Rwandans are saying. That's the position here. So I'm not saying...
Sorry.
No, you finish.
I was going to say, I'm not saying as a matter of principle that the Secretary of State can't command respect, her views can't command respect, in this terrain, which the UNHCR says is totally unique. There's never been a case...
Well, stop qualifying, just get to the point. No, they're not saying as a matter of principle.
As a matter of principle.
But
here, no respect at all on the question of capability, because they're not there, except for a few months latterly. And
so they're not there, you mean?
In Rwanda. The UNHCR have been in Rwanda since 1993.
No, I understand that, but you're saying because... I'm not asking for a comparison with the UNHCR. I'm asking about whether you're saying the Foreign Office, effectively, or a Home Office team used to country assessment, is entitled to no respect for its judgment on the ability of a foreign government to change its systems.
I don't make that argument as a matter of principle, that they are. But on the facts here, we say no, and no, given that you've got a different, independent source of evidence who are far better qualified for all sorts of reasons to give their views. I was on my second point in Ottman, and that is that it showed excessive deference to the Secretary of State's assessment. And this is in a context where the question is a real-world question which concerns what would happen on the ground. The third point we make is that this was essentially because, as I've just said, a key feature in the case which the court didn't consider, but was bound to. The assurances concerned significant changes to an existing process, unique in UNHCR's experience, and in our researches too, which raised key questions of A, what was wrong with the system? What was needed to remedy the failings? Could they be remedied at all? And in what time frames? And this isn't a point about the difference between positive and negative obligations, which is what the Secretary of State casts it as, paragraph 43. But the difference between assurances which, as a matter of volition, the state can provide, Jordan, we won't torture, and those with which the best will in the world can't, because they depend upon understanding, capacity, training, resources to be fulfilled. As the UNHCR says in its observations, a necessary question is, are the flaws in the system suitable for assurances? That's her UNHCR observations, paragraph 37. And so, at paragraph 49.1 of our skeleton, we say that the issue of Rwandan good faith was not the only, still less the primary issue. And the court erred in failing to recognise this in its paragraphs, paragraph 63 and 66.
So you're saying this is 49.1 of your skeleton?
Of our skeleton, yes. 49.1 of our skeleton. And the court didn't recognise this at 63 and 66, despite express submissions to the contrary. History of bilateral relations was only a part of, we say a less important part of, certainly wasn't dispositive of the issue. So the more important issues were whether the assurances were fit for purpose, assuming the best in the world. Could they deliver a proper system? And on that issue, we say it was certainly wrong for the court on the facts here to consider that the Secretary of State's assessment commanded preeminent weight. For reasons I've already adverted to, the UNHCR was the expert body. And then at 49.3, the expert body's view was that there are systemic and structurally inbuilt problems, some of which can only be remedied by structural changes, long-term capacity building. That's Botnick 2, paragraph 148, page 1727, 596. Training, expertise, quality of lawyers, representation by lawyers, a quote sticking point. The Rwandans, it looks like you're going to get lawyers at the stage of appeal to the High Court. You get assistance before, but you don't have representation. It looks like not clear.
I don't want to slow you down, but if one of your team could find out how many lawyers practice in Rwanda and the population of Rwanda,
yeah,
I would be very grateful.
Would you like lawyers or refugee or people with refugee law expertise?
Well, whichever you both, if you can give them.
There's material in Botnick on this. I don't have it at my fingers. We'll certainly give it to you. Sorry about
These are questions I ask about every country wherever I go.
Very interesting. So he training, expertise, lawyers, proper processes in context where there's going to be no parallel system. Rights of appeal, capture of judiciary. DGIEI role maintained in the system because not acknowledged. And I'll just give you a reference, if I may. UNHCR observations below, file 2, common file 2, common bundle 2, tab 12, page 657, para 18.2, where they say very quickly, Rwanda points out DGIA has no authority in Rwandan law to do this. UNHCR agrees. It's unequivocal that the practice is indeed occurring. Rwanda's government's failure to acknowledge the practice, still less that it must be stopped, is of grave concern, has the consequence that the Rwandan government has set out no plans to prevent this from continuing under the Rwanda arrangement. Rather, the government of Rwanda's explanation to Secretary of State that the DGI say the process is already in operation. This is not a new process. So these are all concerning matters. So the fourth point I wanted to make, the Divisional Court at 62, we say they were wrong to say that on their face, the obligations address all significant concerns raised in the UNHCR's evidence. What about training? What about capacity? What about the independence of the judiciary? So that facial question, on their face, we say they got that wrong. But that's, of course, not the question. That was not the question the court should have asked. The issue isn't one of textual coverage, but rather what's going to happen as a matter of practice. What about refoulement? It's all very well to have refoulement in your arrangement. It's a problem if the other state doesn't understand what it means. And then continuing, my lords, in Divisional Court at 65, it did not address the practical issues. It asked the facial question, and then it didn't properly address the practical issues because it acknowledged that it will take time and resources. But it didn't ask how much time, how many resources, and what's going to happen in the interim period. It referred to Rwanda's prior consent to transfer. I've already made the point in answer to my Lord Master of Rolls that UNHCR's concerns were qualitative as well as quantitative. It then referred to monitoring and financial incentives in paragraph 65. I'll come on to that in a minute.
You say that the court should have been asking the question I put to you earlier, substantial grounds linking a real risk, in the case of each person.
Yes.
The court should have been asking that
Yes.
in relation to each person.
Yes.
Concerned.
Yes.
Right.
Well, each of the appellants in
Yes.
each of those who were
Before the
parties,
Of course.
and so what? That it's not appropriate to have a generic argument at all.
No.
I'm puzzled. I thought
No,
this
no.
was all about
No.
generics.
Sorry. The risk arises from generic factors.
Yes.
To
So
the individuals.
Your
These individuals. Sorry.
yes. The case being advanced is that anybody and everybody who might be removed to Rwanda would face the same problems.
Yes.
And so they're not individual fact specific in this appeal. I appreciate there are all sorts of arguments before the Divisional Court about individuals.
Yeah.
Yes.
My Lord has it absolutely right. I'm sorry if I gave a misleading
But
answer.
as regards timing, if there's a length of time, you might have to reconsider over time because it affects individuals in April today and in August.
Yes, but
Things may have changed. There may be a risk in April, but not in August. I mean, there might be. I'm not saying it would be a generic risk, but it might be different at different times.
yes, but the court does not engage with that temporal issue. It just says it will take time and resources, but doesn't.
But the way it could play out, couldn't it? Let us suppose, and the evidence doesn't quite put it this way, but there's a flavour of it, that there are one or two people in the Rwandan system who understand refugee law, but they couldn't cope with any great number of cases. If the evidence were that it would have the capacity to deal with 20 people, but not with 200, how should the court, but it might have the evidence to deal with 200, the capacity to deal with 200 in a year's time, because by then further institutional competence would have been built up, there would have been room for further training, and so on. The court would, if that were the evidence, be entitled to find that as long as not too many people went, the Rwandans could deal with them properly.
Yeah, you're putting a hypothesis to me, my Lord.
Well, I know I am, but I'm just trying to work out what the principle is. It really comes off the back of my Lord's question.
Yes, because I have. You appreciate I have factual answers about
Well, you can put that in a second.
Principle.
But in principle,
Yes.
that might be the case, mightn't it?
Yeah, it's an important question. I'm going to get a little bit of help. If the concern was simply numbers, yes. So that's my in-principle answer. If it's a pure capacity issue in the sense that we can deal with 5 but not 50, yes. But that you'd have to have evidence to show that. In this case, you haven't. So my second part of my answer on the facts, no, you don't, because look at structural issues like judicial independence, lack of training, lack of understanding of basic concepts, misunderstanding of reform.
This may flow into the Gillick argument. I'm not sure, but your argument is sound. You would submit if only one person were removed to
Yes.
Rwanda.
On the facts, absolutely.
Yes, that's your case.
It is.
because it's, in essence, your submission, and now the position of the UNHCR is that Rwanda is incapable safely of dealing with any asylum claims at all. As I understand, I mean, that's really what it comes to, isn't it?
No, absolutely. There is a real risk. The question is there a real risk that you have access to a safe and reliable system? And the answer is yes, there is a real risk, because the system is not safe and reliable.
Yes.
It just isn't.
Yes.
As a matter of practical reality, for all the reasons that they have given and I've sought to advance to. So James relies on appeals. You haven't got an independent appeal. There's no understanding. They don't understand basic concepts. They don't understand reform, with great respect. The DGI thinks it's okay to deny access to asylum procedures on the basis of palatability or international relations or security concerns. They're very concerning matters. The fifth point I was going to make of my 7 was that as the basic assurance that's given, this is our paragraph 50, subparagraph 1, is to act in accordance.
I'm sorry, Mr. Wilson, but I want to understand this really properly. And you say the assurances would be given respect so far as the government of Rwanda's good faith and intention to comply, but you say on the evidence there are no real grounds for supposing they can comply in such a short time scale. They might be able to.
That's the first point I want to make. And I'm also going to come on to the good faith issue and say that the Secretary of State's conclusion there, albeit in principle it commands respect, was vitiated by a failure to consider mandatory, centrally relevant considerations. I'm going to come on to that. I hope I made that clear.
Yes. But you
as
do say what I put to you.
Yeah. Everything else being equal, the Secretary of State is entitled to command greater respect on the question of good faith than on the question of ability, suitability of the assurances. She may be able to claim respect on that as well. In this case, no. And in this case, good faith also, the expectation of good faith is vitiated by mandatory relevant factors which she didn't consider. So the fifth point I was going to make was that the basic assurance, which is to act in accordance with the Refugee Convention, is vague. And it's vague because they don't understand it. Rwanda thinks you've got to claim immediately, that you can't be deceitful, that you've got to comply with their immigration laws. And it thinks that if you're unpalatable, your claim may be refused or rejected for international relations or security concerns. It thinks that if you're chain reform, it's not reformable. So you would need a bespoke scheme. A bespoke scheme would address those questions. And instead what you have is something broad and vague. It is something that is simply reflective of a pre-existing obligation, which on any view, let alone the correct view, is flouting the absolutely key obligation that is relevant. The sixth point I wanted to make was monitoring, and this, I suppose, straddled both the question of good faith, can they keep their promises, and also the suitability issue. So monitoring, we say, paragraph 50.6 of our skeleton, we say, firstly, this is not an exacting monitoring mechanism for reasons set out in paragraph 50.6. The terms of reference are set out in two places. Secretary of State has them in her, the relevant extract, she has them in her footnote 59. In your bundles, you have the terms of reference at bundle 4, that's common bundle 4, tab 70, page 1355. And the points that we've made.
Give us a moment. Yes.
The points that we've made are there's no enforcement power. They can't bind. While their membership is independent of the parties, they can only report to the joint committee, whose membership comprises senior officials, including the DGIE. And for good measure, their recommendations aren't binding either. That's the MOU 21.2.1. So the monitoring is intended to be high level, with no provision to protect rights in individual cases, with no metric for assessment other than broadly compliance with the assurances. And we see from the extract at Secretary of State footnote 59, what's envisaged is visits, attending various stages, reviewing paperwork, not anything that can have real impact if things go wrong. It lacks teeth. So there is a real risk, we say, of insufficiently independent, thorough, or effective monitoring. As UNHCR says, their observations, para 39, it's inherently difficult to monitor, for example, whether the process was fair or whether there's been a clandestine removal across the border to a fourth country. How does one detect a failure properly to elicit an account by an untrained officer, or the missteps made by inadequate legal assistance, or the gap created by an inability to have a lawyer present in proceedings, even if there is assistance? The Secretary of State says, my lords, at footnote 54, that all notifications of RSDC decisions are shared with the UNHCR. This is another example where Rwandan information is not correct.
Sorry, when you have UNHCR, I'm getting confused with acronyms, that's all.
Sorry, my lord?
You said it's shared with somebody. And you used
The UN.
Oh, the UNHCR.
Yeah.
I lost the H in.
Yeah, sorry.
I'm sure that was my fault.
It's my fault. No, they say UNHCR gets everything.
Yep.
And she relies at footnote 54 on the government.
Sorry, all this rushing about, you must give us a chance to get to the references. So, Secretary of State footnote 54.
Yes. She says all
I haven't
notifications.
got it to it yet. Yes.
All notifications of RSDC decisions are shared with the UNHCR.
Yeah.
That is an example, another example, where Rwandan information is incorrect. Her reference is wrong. It's not tab 79, it's tab 76 in that footnote. But you've got the reference there. It's answered by.
I'm sorry, Mr. Hussain, again, it's entirely my fault. Am I in the right footnote? This is in the Secretary of State's skeleton. Yeah?
Yes. My lord, yes.
53, the quarterly report will detail the outcome of each asylum claim and or appeal. Is it that one?
No, it's 54.
Exhibit KA 147 at row 33.
Yes. And 79 is wrong, it should be 76.
Okay, I'll change
And you'll
that.
see the sentence to which it refers, all notifications of decisions by the RSDC are shared with the UNHCR. That's the Secretary of State's case. She relies upon Rwandan. The exhibit is the Rwandan information table. Mr. Botnick addresses this issue in his paragraphs, Botnick 2, para 18 to 19a, where he says, this is page 1681, Common Bundle 5, tab 96, UNHCR is not informed systematically by Rwanda of all claims.
Sorry, I haven't got.
Well, isn't this speaking about the future?
No.
No? Okay.
No, because if that information table.
The information table is meant to meet the earlier criticisms,
Yes.
and therefore.
And the verb is are shared, not will be.
Okay.
But sorry, was it Mr. Botnick 3 or Mr. Botnick 2?
Two.
Which page?
It's both. It's two,
Okay.
and he addresses it both in 2 and 3. 2, first of all,
Right.
18 to 19A. Tab 96, page 1681, volume 5. And then
81 do sell 1691.
1681.
81, thank you. $19A, did you say?
Yes.
Yep.
Okay, and then Botnick 3, which is in the same bundle at 104 at paragraph 7A, where he confirms that. And then
Just before you go there, could you look at 1682, which you were at before?
sorry, James.
1682, paragraph 21, Botnick 2.
Recently, Myanmar has sent UNHCR copies of RSDC decisions. UNHCR doesn't know if it's been sent copies of all or only some decisions.
Okay.
It's a recent development, not clear whether it's all, thank you. And then, so Botnick 3 is 7A, page 1764. UNHCR isn't provided with comprehensive information, and then over the page at Roman 4, UNHCR believes it doesn't know about all RSD cases because Rwanda has not shared with it all decisions by the RSDC. This may explain instances where more italicized cases appear in the government of Rwanda's data set.
I'm sorry, where are you reading from?
Page 1765,
Yep,
middle of the page,
yep,
Roman 4.
thank you.
And that's RSDC. And if you look across the page, 1766, it doesn't get any information about DGIE rejections because the Rwandans presumably say that doesn't occur, even though it does. UNHCR's evidence. Do you see that? Then, my lords, just on monitoring, in one of her overarching points at paragraph 5, she relies upon the presumption of close monitoring by the UNHCR. We say that is a surprising submission. And it's surprising we respectfully submit because there will also be close monitoring by the UNHCR and is anticipated by the legal representative, paragraph 5. It's wrong for a number of reasons. Firstly, the obligation is on the Secretary of State. You can't delegate that to the UNHCR, that's the first point. Second point, the UNHCR doesn't have any formal role within the NEDP construct. And the third point, as you've seen, is that it's denied access to significant parts of the Rwandan RSD system. And the references are, if you look at UNHCR observations paragraph 4, they say,
in this court.
yes, in this court, yes. I'll make it clear if it's the court below. In this court, they say at paragraph 4, they play no official role in Rwanda's RSD system for individualised decision making, and notwithstanding provision for this in Rwandan legislation and UNHCR requests, they've been denied observer status in RSD decisions. And then we make the point that in the course of these proceedings, the Rwandan government has railed against the UNHCR, accusing it of making overstated claims. You'll have seen that. Deliberate misinterpretation of the full law. And that is hardly a promising start, we say, for this so-called monitoring by the UNHCR that the Secretary of State has in mind. And there are references where the Secretary of State recognises that the government of Rwanda are clear that they don't want the UNHCR to play a supervisory role. Mr. Armstrong's email, 17th June, volume 4, tab 65, page 1328. The final point I wanted to make about UNHCR is that it is surprising, perhaps unfortunate, that this appears in the Secretary of State skeleton, because a similar claim made in correspondence last June, UNHCR was closely involved in the MEDP and will, quoting, and will provide oversight of individuals relocated from the UK, was accepted by the Secretary of State to be inaccurate and indeed was the subject of an apology by Mr. Hobbs. And see UNHCR observations 6.2. The apology is at page 1650.
Which tab, which bundle?
Bundle 5, tab 91. Common bundle 5, tab 91, 1650, Mr. Hobbs' statement apologising for that statement. And there are examples. One of my clients, AT, he has a letter where the Secretary of State says that and then apologises for it. And yet you have it again in this court. And the letter is at bundle 7, which is AAA core, tab 20, page 679, para 41. That's the UNHCR. Perhaps Sir James will apologise again, I don't know, matter to him. What about the appellant's representatives? Even assuming we would be able to monitor each of our clients' progress through the Rwandan system, what we would rhetorically ask could we possibly do if something untoward or even malign happens to them? Which court would we go to? How could we prevent them from being refooled? How could they enforce rights under the non-binding and non-justiciable MOU? And interestingly, it is no part of the Divisional Court's reasoning that the UNHCR or solicitors could monitor. This appears to be, with great respect, an impermissible and evidentially ill-founded forensic frolic by the Secretary of State. The seventh point
I don't spend time. Can your juniors just check and give us the correct reference for what I understood was an email? 7, I got down bundle 7, tab 20, page 679, para 41. Doesn't appear.
That is the letter.
It isn't a letter.
Bundle 7, tab 20.
Page 679, para 41.
Is not part of the letter.
Oh, I see, part of the Home Office letter. I'm
yes.
so sorry. Yes, okay.
Do you have that paragraph?
I have now.
It's the last sentence.
Last sentence.
UNHCR.
Yes, I see. Thank you. Right.
And the apology from Mr. Hobbs.
That's what Hobbs was apologising for.
And that was one of 7.
Yeah, okay, thank you. Sorry about that.
So the seventh point, not at all, my lord. The seventh point I was going to make is that assume that the assurance is a magic wand, you can deliver a safe system, so this is good faith. There are reasons not to trust the authorities with great respect, which required consideration, but there's no evidence that they were considered, and these were overlooked by the Divisional Court. And so the first issue is the indication of a willingness to cooperate in the face of a breach or investigate. Very central consideration in these cases. That's our skeleton at 50.2. You've already seen the rather belligerent response to the UNHCR in the 11th of May note of unfortunately, it's consistent with previous engagement with other UN bodies, and we've set out the engagement with the UN Subcommittee for the Prevention of Torture and UNCAT. There's no consideration by Mr. Mustard, upon whose evidence Secretary of State Century relies on this issue, good faith, about the Netazarayu case and the fact that the Rwandan government were threatening to kill its dissidents here at the same time as there was an MOU in place. And the Secretary of State at 45.2 in her skeleton says that the government of Rwanda has indicated a clear willingness to cooperate with international monitoring mechanisms and has been engaging with and responding to UNHCR criticisms. We say, with great respect, that's just not available remotely on the evidence. The second reason, the second consideration that required engagement didn't receive any, it is Israel-Rwanda. Now, this was obviously relevant as part of the receiving, so this is Ottman 189.7. Classic, you'll be aware of it. It's part and parcel of the consideration relating to the length and strength of bilateral relations. And one of the things you've got to look at is the receiving state's record in abiding by similar assurances. We accept, as my Lord, the Lord Chief Justice said, that Ottman isn't a tick box and that the impact or weight of factors will vary depending on the individual circumstances of the case. That's the GS and Hungary case. You recognise, my Lord, in that case at Power 32, that it was obvious that past compliance was relevant. That was the phrase that you used, obvious. We've got GS Hungary, if you want it, the reference to it. Volume 20, core. Para 41. Sorry, tab 41. Page 1290, paragraph 32. And the Secretary of State on this issue in Israel, as you've got the point, can't say financial incentives would appear to be very different. We just don't know what the evidence is. And conditional foreign aid, I'm not going to say very much about that. You've got the our skeleton 50.5 regarding vagueness. The Secretary of State says, well, we are very vague here. We get the information from Mr. Mustard. Hard volume 3, common bundle 3, tab 32, page 1106, paragraph 7 to 8, where he talks about the suspension of general budget support to Rwanda due to its role in the DRC conflict and the decision in 2014 to cut all sector budget support following the assassination of a Rwandan dissident in Saudi Arabia. The Rwandan government is still involved in the DRC conflict and has, on the Secretary of State's own evidence, coerced refugees to conduct armed operations abroad. And we discussed that in our skeleton below at 175 to 176 and 200. Lastly, financial incentives. Divisional Court 65. These were not disclosed to us. The funding note verbal were not disclosed to us on the basis that the Secretary of State would not be relying upon the detail of the financial incentives, and it was said that they were not relevant. They couldn't be evaluated in any detail. This is in the context where the accounting officer, Mr. Rycroft, now Sir Matthew, had said that the fraud risk is very high. £140 million has already been paid and therefore can't ex hypothesi act as an incentive. Those are my submissions on Ottman, ground 4. Can I then please move to I'm just going to take them out of order slightly, if I may. I'm going to return to ground 9, which is section 2 of the 93 Act. And I'm going to take you now, if I may, to the Article 31 ground. It was removal of penalty. And here...
What number is that, remind me?
Right, so it's ground 11.
Ground 11.
Yeah. Your ground 11.
Penalty.
Our skeleton 59 to 67. So this turned upon the proposition, the court's approach at paragraph 123 to 126 turned on the proposition essentially that removal is not a penalty on the basis of academic commentary on the Travo. We accept that removal per se is not a penalty. And we think that the best explanation for that is because a special meaning was intended by the drafters that expulsion should not be a penalty. And that's, you've got VCLT Article 31.4 in your bundles if you want it.
We got what, sorry?
Vienna Convention on Law of Criminal.
Oh, sorry.
Do you want the reference to it?
No, I just didn't understand the acronym.
So, would you like the reference to it in the bundle?
What, to the convention?
Yes.
No.
So 31.4, and it's because on first principles it's plain that expulsion could be a penalty unless penalty has to be criminal. I'll leave that aside. But does that mean that expulsion is never a penalty? I mean, that's the question. And the Travo, as far as we are aware, did not concern the sort of offshoring or burden shifting arrangement, as UNHCR put it, that we're now concerned with. Our skeleton at paragraph 62, we make the submission that the court ignored the broad interpretation of Article 31 that's been given by our courts and of penalty. And that flows from the Vienna Convention, which the court did not consider, except when it turned to a different argument made by Mr. Drabble about whether the Refugee Convention imposes a duty to consider a claim. That's Divisional Court at 121. It just focused on academic commentators and the Travo, nor did it consider a very important case from the Canadian Supreme Court. I'm going to spend a few minutes on that, if I may. And this is in the context where, at the highest level, it's been recognised that it is desirable to have uniform interpretation. We've given you references in our skeleton at paragraph 60. This is in a context where you don't have a supranational court who can adjudicate on refugee convention matters at the suit of an individual. Article 40 provides for interstate disputes before the ICJ. It's never, at least not yet, been invoked. And then to the Canadian Supreme Court, I want to take you to that, if I may, because that is absolutely inconsistent with the proposition that removal, inadmissibility of an asylum claim and removal can never be a penalty. So you have that at volume 22, Core Authorities. tab 77. At page 3564. And you'll see, if I can take you in the head notes, that the issue was the construction of section 37 of the Canadian statutes. In the middle of the page, the result of being ruled inadmissible under that statute is that the refugee claimant is peremptorily excluded from Canada without consideration of his or her claim on the merits. So it concerns the situation that we've got here, inadmissibility and non-access to the territory. It's Chief Justice McLachlan for the court. Her judgment begins at 3572.
Where were the people concerned removed to?
We don't know that. I accept that it wasn't a safe third country situation. There's no indication that was the position, but it's very clear that they were removed.
Yeah.
And if the Secretary of State's position is, as it always has been, as the Divisional Court accepted, that removal can never be a penalty, well, this judgment is inconsistent with that, because the court held that it was in these circumstances. And you'll see at paragraph 14, Lady Justice McLachlan, in the passage I've just referred you to in the head notes, paragraph 14, 3576, the result of being ruled inadmissible is that the refugee claimant is peremptorily excluded, and so forth. So I should have just mentioned paragraphs 7 to 11 of the judgment, which outline the facts. You'll see it's not a small boats case, but if I can put it this way, a larger boats case. It concerns a 3-month voyage to Canada. The issues concern, as the Secretary says, and we accept, the construction of the domestic statute. That's at 18 to 20, 3577. The statute itself is set out at 27, 3579. The international law context is set out at paragraph 47 at 3585. Contextual significance of international law. And then paragraph 50, consider Palermo and Refugee Convention 3586. And then the key paragraph is the first key paragraph is at 57, 3589, where the court says this. Having cited Article 31, it says the import of this provision for domestic admissibility provisions is clear. As A.T. Gallagher and F. David put it, Dr. Gallagher is a very preeminent academic. My Lord, the Vice President may recall we went to her work in the trafficking case some years ago. An individual cannot be denied refugee status, or most importantly, the opportunity to make a claim for such status through fair assessment procedures, solely because of the way in which that person sought or secured entry into the country of destination. Obstructed or delayed access to the refugee process is a penalty within the meaning of Article 31. And then at 58...
Sorry, that last point, that is may be very correct, but that's nevertheless just simply the view of the authors. It's not, there's no provision to that effect.
Yes, sorry.
I just wanted to make clear that
No, it's
That's all that's being said. It's summarising what their view is.
no. It's the import of this provision. It's clear. They're citing this with approval, and then if you look at on,
Yes, I see.
it's clear that that's the interpretation that they give. 58. It's indisputable that just as the statute must be read against the backdrop of Canadian international commitments to combat organised criminal people smuggling, it must also be read in a way that's consistent with the Refugee Convention. And then over the page, so over 2 pages, so this is 3591, they say at 63, respondents contend Article 31 refers only to criminal penalties. This interpretation runs counter to the purpose of Article 31 and the weight of academic commentary. See various authors. The generally accepted view is that denying a person access to the refugee claim process on account of his legal entry is a penalty within the meaning of Article 31. The law recognises the reality that refugees often flee in groups, work together, and so forth. Article 31 doesn't permit a state to deny refugee protection or refugee determination procedures to refugees solely because they've aided others to enter illegally, and so forth. So we say that is absolutely on all fours with our situation, except that I accept that there isn't a safe third country context. But we say that is completely irrelevant, because if that made all the difference, the Secretary of State, the question arises, why isn't the court saying there's a breach of Article 33 here? It's squarely basing its decision on Article 31 in circumstances where it's held that obstructed or denied access is a penalty in the view of respected academics, and it supports that conclusion at 63. Now, the Secretary of State says I've dealt with her responses. No safe third country. It's primarily construing as Canadian statute, yes, but you've seen what it says at 57, 58. The Secretary of State also suggests that the position in domestic law about whether penalty is only criminal, she suggests it's settled by reference to as for paragraph 60 of her skeleton, Romans 3 to 4. That's absolutely not the case. The House of Lords in Asphalt didn't consider the issue because the case was a criminal case. And in that case, their lordships, majority of their lordships, adopted a highly purposive construction to Article 31 to include departure. Article 31 says illegal entry or presence. They read that to include departure. So it was an example of a purposive approach to Article 31. The idea that authority, as for is authority control position, that penalty can only mean criminal penalty, we say is simply wrong, and the issue didn't arise. Our positive case, with the support of this Canadian judgment, we set out at 63, and where we say that removal per se is not always a penalty, but inadmissibility, including as a precursor to removal, maybe. Secondly, the reasons why and the conditions to which a person is removed are relevant, and here there is a penalty. At our skeleton 64 to 65, we say that is because there is a detriment in objective terms, given the inferior processes that obtain in Rwanda, its poor human rights record. The detriment is imposed for deterrent purposes. We've given you references for that.
So what's the principle? First of all, you don't submit that it's never possible to outsource these.
So Dublin, I'm coming on to that.
Yes.
The reason Dublin isn't a penalty, CR skeleton 64, is for two reasons. Firstly, there's a hard wiring of proper asylum processes and respect for human rights in the scheme. So there is, we say, no objective detriment. Defeating a subjective preference for forum shopping isn't enough. You've got to judge this by objective standards.
Well, the irony of that submission is that there have been successful arguments that a number of EU states don't do asylum claims properly. Greece, Italy.
Yes.
We've had arguments in this court about Sweden.
Yes.
And I think France. And
yes.
Greece
yes,
didn't fall apart at the EU level, but did in Strasbourg.
No, but yeah, Strasbourg isn't considering Article 31. It doesn't have jurisdiction.
No. But your submission was that within the EU, one could assume that everybody subscribed to the same human rights norms and presumably applied them. But I can imagine the number of cases where it could be suggested that may not be so.
It's not an assumption. It's a requirement in I think, Article 4.1 of the TFEU. So you're well aware of that, by the way. In the extradition context, mutual trust and confidence.
Yes.
It's absolutely hardwired in. If standards fall, then that's an aberration. But the scheme, it is human rights protection is absolutely hardwired in. And then you had what's
hang on,
called...
what do you mean? But why is that a distinction from Rwanda? It's hardwired in to EU countries by EU legislation and the Charter. It would be said it is hardwired into Rwanda by the requirements of the Rwandan constitution. So you've just come back to a factual question as to whether that's really so.
Yeah, but my lord, no one seriously contends that. The Secretary of State's own witnesses don't contend that. The Divisional Court here didn't consent that Rwanda is a state that respects human rights.
But I think that my lord's question is really trying to get to the principle that needs to be applied in these cases.
It's, as Lord Bingham used to say, your lordship will recall, the test is easy to state. It may be more difficult to apply.
You haven't stated it yet, except by using the language of hardwired, which is a metaphor.
No, sorry. The question is there objective detriment? And there will not be objective detriment if you're not being removed to inferior processes.
Okay, hang on 1 second. Sorry, is this quoting from your skeleton? It's not a...
No, it flows from the skeleton. I'm just giving you...
No, that's fine. So no objective detriment if not being removed to, what was the word?
Inferior asylum processes and human rights compliance.
But under Dublin, you often were being removed to places with inferior asylum processes and human rights compliance.
Yes, my lord, but
that's what you argued to me in Sudan.
Yes, no, I did. Yes,
sorry,
no, I will remember. But my lord, that wasn't an Article 31 case. Apart from anything else, Article 31, it is not one of the articles of the Refugee Convention which is in the EU asylum scheme. It's not replicated in those directives.
No, but your point isn't based on Article 31. Your point is inferior asylum processes and human rights compliance.
It's all based. The whole thing is about Article 31. The whole thing is about whether it's a penalty in Article 31. Sorry.
But if you put it in that way, there's no detriment if you're not being removed to inferior processes and which are and human rights compliance was what I wrote down. Does it actually add anything to the arguments that you've already advanced?
Yes, it does, because what I've got to show under Article 33 is that they would be so bad as to amount to refoulement. Nobody can seriously contest that. I don't think Secretary of State does, that Rwanda has a very poor human rights record.
No, I'm thinking
but there's a hermetic...
Thinking more of the arguments you've already deployed about Sirring and Ilias and Tameside and all the rest of it.
If I succeed on them,
then this is irrelevant. But does it really add anything? Is it not the same argument?
The court held that you confuse 31 with 33 because it's about expulsion, and the only article that concerns expulsion is Article 33. Relevantly, there's another one as well. We'll get into that. It's 33 which concerns expulsion. If that's right, why didn't the Canadian case base its decision on 33? Why did it do so on 31? And if I get home on the other arguments, no, this I would have a bigger win if you like. But on 31, I don't need to hit that standard. In response to my lord, I think I did give a very helpful answer. I didn't mean to be glib earlier, my lord the Vice President. The other feature of Dublin that's very significant is, of course, that it doesn't respond to illegal entry. It's not supposed to. Doesn't have a deterrent aspect either, because Dublin was based upon inter alia, family member presence, residence, and so forth. So is this going to be a penalty on account of illegal entry or presence? We have that here, and we have the deterrent aspect.
But doesn't Dublin seek to deter people from failing to apply for asylum in the first safe country they travel through? There is a very powerful deterrent element in the context of its application in over decades here. Yes. Yes. It was removal under Dublin to deter people travelling all the way through Europe, through perhaps 4, 5, 6 safe countries to claim asylum in the UK, and the same was apparent in Scandinavia in particular.
Yes, but it didn't respond to illegal entry or presence.
No. But your submission was it wasn't a deterrent mechanism, but it is precisely that, isn't it? In all its
I see the force of that one.
Yes.
I see. So, what we have here is deterrence plus objective detriment, i.e., the inferior RSD processes and lack of respect for human rights.
Yes.
And I'll see the points that my learned friend Lord Panic makes in response and come back to all the matters in reply. On ground 8, can I take that next, which is the virus ground? And I'll come back to section 2 in the whatever time I've got. Isn't very much. So this is ground 8. This is Viries, Schedule 3 of the 2004 Act. We say this is a hard-edged question of Viries or circumvention, Padfield, of the statutory scheme. There are 5 points we wish to make.
Are these 5 points made in your skeleton?
It just helps me to note. But if you could please take a note, because I'm just trying to crystallise in my skeleton.
No, just so that I know.
68 to 73. So the distinction between the parties' positions concerns whether or not the Secretary of State can lawfully set out in a policy document the conclusion that Rwanda is, save in exceptional circumstances, a safe third country for asylum seekers. We say she can't, because Parliament has legislated for the establishment of such presumptions by way of, to be made by way of statutory instruments.
That's the first of your points.
The first point. The statutory scheme, I'm not going to take you to it given the time, shows that its purpose is to establish presumptions that are either rebuttable, human rights, or not rebuttable, refugee convention. The part under which the Secretary has proceeded lays emphasis on individuals. The third point I wanted to make is to show you or give references where the Secretary has said that Rwanda is fundamentally safe. We say that's a circumvention of the statutory scheme. It's ultra vires or Padfield improper to use the administrative power to publish CPIN's assessments to achieve an outcome that may only be secured by the statutory instrument. And we see that most clearly in a number of places, but if you look at the Secretary of State's asylum aid skeleton, she says at paragraph 29.2, if I could just give you the reference of the Secretary of State's asylum aid skeleton, the Secretary of State has said that if any representations are made on wider issues, including the status of Rwanda as a safe third country, they will in fact be considered. This is a voluntary statement not mandated by law. And paragraph 41 of that same skeleton, she says it's self-evident that the generic question as to the status of Rwanda as a safe third country, relevant to every applicant, is distinct from the question of personal characteristics and so forth. And then one sees how the scales aren't empty when she's considering whether to move to Rwanda in a document. This is Rwanda information note. This is at Common 3. Please, if I could just give you the reference. Common 3, tab 25, pages 1000 to 1001, where asylum seekers are told Rwanda is a fundamentally safe and secure country with a track record of supporting asylum seekers. Under this agreement, they will process claims in accordance with the UN Refugee Convention, national and international human rights laws. If you feel that Rwanda isn't safe for you personally, you must notify us immediately in writing or in person and explain why. And we say it's very difficult to tell the difference between a formal presumption, which the applicant must rebut, and the approach to Rwanda where applicants are told that His Majesty's government thinks Rwanda is fundamentally safe and secure, and it's for the individual to explain why that conclusion shouldn't apply. Secretary of State offers two answers to this. It absolutely does not, our argument absolutely does not lead to the conclusion that Secretary of State can't publish country-specific general material. The distinction is between general material that sets out evidence relevant to a country, the conditions there, the difference between generic material and a generic conclusion as regards the safety of that country. The critical question is whether the scales start empty as to the overarching question whether a country is safe. The next point that I wanted to address, the second answer that Secretary of State gives, is that the statutory presumptions are somewhat different. The gravamen of the argument against us seems to be that this isn't Padfield improper because it's not creating a statutory presumption. We say functionally that that's neither here nor there. That's a distinction without a difference. It's unclear why a decision maker would adopt a legally different approach if the presumption is set out in the statutory instrument as opposed to a general assessment. Indeed, the inclusion in a general assessment might make it more difficult to rebut because it will be set out in detail with reasoning to support it. That's given the time of what I was going to say about that ground. And then the final ground, if I may, is ground 9, which is section 2 of the 1993 Act. That's our skeleton 51 to 57. I just want to make 5 points, if I may.
Have I muddled myself? I'm sure I have. This is the point that you're taking the lead on rather than Mr. Travel, is it?
He's got a different argument, yes.
Oh, sorry. Well, it's obviously the time of the afternoon. Yeah.
So it's ground 9.
Yes.
Our skeletons 51 to 57. 5 points. 1, there's no contest about what section 2 means if it applies. The court must decide for itself the varies of the question driven by section 2. Is there practice, or would the practice be contrary to the Refugee Convention? I'll come back to what the section catches. does it only apply to rules or does it also apply to policies? Secretary of State in her skeleton at paragraph 52 effectively says it just applies to rules. The Divisional Court flirted with that idea at paragraph 122 of the judgment. It thought it applied just to the rules, but didn't dismiss the ground on that basis. The second point I want to make is that we had said to this Divisional Court that it had to examine the compatibility of the policy with the full set of obligations owed under the Refugee Convention, and the ones that we identified as germane were Articles 33. That we said Section 2 gave you a vires route into Article 33. That's refoulement. Article 1C, that's cessation. Article 1F, that's exclusion. And Article 15, that's rights of association. Secretary of State, with respect, misses the point at her skeleton in paragraph 53, because, as I've made the point earlier, we challenged the Secretary of State's conclusion both on a rationality basis. That's the provision that the Secretary of State cites, but also as a matter under Section 2. Now, the references that you've got are 150 to 154, which give you the references. If I had time, I'd show you. But it's very clear that we were challenging, before the Divisional Court, the policy on 4 Refugee Convention articles under Section 2, the ones I've just mentioned. It's not correct to suggest, as the Secretary of State does at 53, that this argument is surprising to quote only partially from our skeleton, which is what she does. She says at 53, this is a surprising position because we were challenging it on rationality. Well, yeah, but we were also challenging this as a matter of right. The third point I wanted to make is that the court doesn't consider Article 1C or 1F at all. It's not right to say that it was neither necessary nor possible for it to conduct a predictive exercise. It predicted Article 13. Indeed, it predicted whether Article 15 would be breached. Why could it not predict whether cessation or exclusion protections would be breached? It's then said against us that this wasn't necessary. The answer to that is that the Convention envisages developing degrees of attachment with the host state accrued through long-term stay. Rights are granted on the basis of presence in the jurisdiction, presence on territory, lawful presence, lawful stay. Article 34 talks about assimilation and naturalisation, best efforts. But there was no temporal limitation there, we say. There's no answer, and the court just doesn't consider it. The fourth point we make in our skeleton at 57 is that the court looked at Article 15 in the passages I mentioned where it does look at the Article 3 protest question for itself. It adopted the correct approach in terms of asking the question for itself, we accept that, but it erred for the reasons we give in our skeleton at 57. And then the last point I want to make is the new legal point, which the Secretary takes. It's not taken below. It would need a respondent's notice. It's a pure point of law, so I'm happy briefly to address it. And that is that Section 2 only applies to the rules. We address this preemptively, if you like, at paragraph 58, where we cite authority to show that it's very clear that it applies to policies and practices as well. This is Lord Steyn in Roma Rights, at paragraph 41, he explains why it also applies to policies, basically immigration rules. There was a lot of debate in the late 70s about the status of the immigration rules. They were called sui generis, cases like Hosenbull. The position is that they're executive statements of policy laid before Parliament subject to negative resolution, but they're executive statements of policy. And the point that Lord Steyn made in Roma Rights was if policies that are subject to legislative imprimatur have to be consistent with the Refugee Convention, but it must follow that administrative practices which aren't also must be. That's the point that he makes. If you've got a hierarchy of regulatory frameworks, acts of Parliament, statutory instruments, rules, policies, the last two come within the scope of Section 2. That obiter statement, which we accept as obiter, has been adopted as correct in law by two cases, not just cases as the Secretary of State says in the lower courts, but two cases in this court, which we give you references to, Ian Serbia and H.A. Child. That's not Mr. It's Lord Justice Baker. That's wrong. Lord Justice Baker. It's the case that becomes GVG, which Mr. Drabble will be addressing you on. Secretary of State says at paragraph 56 that this doesn't advance the argument even if it applies. And we say rhetorically, why not? Because in the immigration context, the central concern is borders, about refusal of entry or removal. Adjectival matters are also obviously addressed in the context of immigration, detention and so forth, right to work. But why wouldn't questions of removal pursuant to policy be within the purview of Section 2? Asylum, the second point you make is asylum analysis is always predictive and based on a hypothesis of removal. The Court of Appeal has long recognised that. I'll give you one reference, if I may. This is Lord Phillips, Master of the Rolls in Sard, and this is volume 29. I hope if you haven't got it, my Lord, the Vice President will get it to you, which is Supplementary 1, tab 19, page 342, para 58, where his lordship says the word would in the relevant statute means that all asylum appeals are based on a hypothesis or assumption of removal. You see the same word would in Section 2 of the Act. That can have two registers. Section 2, nothing in the immigration rules shall lay down any practice which would be contrary to the Refugee Convention. Parliament could easily have said is, although not, which is contrary. It says would. One register would be, well, if the rule or policy is introduced. But the other register, which we rely on, is that it's contemplating a removal. Would in the future. So those are the submissions. I'm sorry to go at such pace, but I wanted to make on Section 2.
Yes, well, thank you.
Would you? Can I hand up? Unless your lordships have any questions. Can I
No. I was just I was wondering what you had in your hand. I thought we had enough.
So this is the homework that my Lord the Vice President sent.
It's my fault.
Yes, so let's have those.
Can it be sent electronically?
Of course. Thank you. Sorry, just some other matters.
Well, I'll tell you what. Why don't? Because we're not going to look at them instantly. No. Because I think Ms. Kilroy needs to get going in a second.
Yes, of course. Sorry.
So, should we have those sent to us after?
Apologies.
When we rise.
Yes.
No, well, thank you very much indeed.
Thank you, Master.
Yes, Miss. Yes. Get your boxes in order.
I'm
No,
just
don't.
trying to organise.
Well, I hope you've time just to sketch the outlines of
Yes.
what you're going to be submitting in more detail tomorrow.
Can I just identify the bundles that we are going to be looking at in this? There are unique bundles 14 and 15, which is the core bundle for asylum aid and supplementary bundle for asylum aid.
Yes.
And then also there are 3 authorities bundles that are directly relevant in asylum aid appeal. Unique numbers 27, 28 and 29. And for my Lord, the Master of the Rolls, it's procedural fairness, supplementary authorities, procedural fairness 1 and 2. And then the final 3rd supplementary authorities bundle that was handed in, I think, last week.
Right. Well, somebody will let me have this electronically overnight because at the moment I only have the original one.
It's joined with the other appeals, so your Lordship should have it. It's a joint supplementary authorities bundle with submitted by the Secretary of State. But it may be that your Lordship will find
They
it.
could be resent overnight. I just have 2 bundles, one on fairness and one the core authorities bundle that have been sent.
We will rectify that. I'm going to follow my skeleton argument very closely. And so I just want to check that you've got the latest version which has the unique bundle numbers in it. It should say on the first line under the heading, references are to unique bundle numbers. But my Lord, Master of Rolls, you're not going to use the unique bundle numbers anyway, so the previous version will be fine.
Can I just check what I've got? Yes, I think I'm in the right place.
I don't think mine.
Let's just.
I don't think mine does. No.
Well, my Lord, it doesn't matter particularly.
But I will. I probably didn't send it, and I'll print it out overnight if I have. Maybe someone will resend it just in case.
Yes, my Lord.
Yep.
And then also the Secretary of State skeleton argument in the asylum aid appeal, which is different. With that housekeeping finished, my Lords, asylum aid's appeal concerns the fairness and lawfulness of the Secretary of State's decision-making procedure for sending people to Rwanda under the MEDP, and in particular, its accelerated timescales. The Divisional Court held that the procedure was lawful and fair. Asylum aid submits it was wrong to do so and advances 6 grounds of appeal, which I will address in turn. My Lords, at the heart of asylum aid's claim is a single proposition. It is that the common law confers real rights. That's the way they were described by the Privy Council in Kanda and Malaya, which are meaningful. That's how they were described by the Court of Appeal in Kirakuma. And worthwhile, which is how they were described in Dudi in the House of Lords. And I'll come to those authorities, and they're all in the skeleton. It does not confer rights which are hollow and futile. That is why the courts have, in more than a century of case law, made clear that fairness in decision-making requires individuals to have effective opportunities to influence the decision, and similarly has emphasised that they must have effective opportunities to access the court. The Divisional Court's judgment conflicts with these basic principles. My Lord, we have summarised the Divisional Court's conclusions on the procedural fairness issue in the skeleton at paragraph 6. In its judgment, the Divisional Court held that the decision on removing individuals to Rwanda could fairly be taken without them having an opportunity to challenge the Secretary of State's view that it was a safe country. That is in the judgment, paragraphs 390 and 392. It held that there was no requirement for them to have enough time to access lawyers in advance of the decision. That's paragraph 403 of the judgment. And no requirement for those lawyers to have time to prepare evidence as to why those individuals at risk of removal would be at risk of ill treatment or other breaches of their rights. That's paragraph 402 to 403. And it also held that there was no need for individuals to be told anything, in summary or otherwise, as to why the Secretary of State had identified them as eligible for removal to Rwanda and why she considered Rwanda safe. That's paragraph 389 of the judgment. As for accessing the court, they could be given only 5 working days to instruct a lawyer, prepare medical or other evidence of their personal circumstances, assemble the materials to allow them to effectively challenge the Secretary of State's view on the safety of Rwanda, draft a judicial review claim, and obtain an injunction. That's judgment paragraph 421. My lords, it is Asylum Aid's case that all these conclusions are obviously wrong in law. Can I turn now to ground 1, which is the first question in the appeal, the scope of common law fairness. It's at paragraph 9 of my skeleton argument. Was the Divisional Court correct to conclude that fairness did not require an opportunity to make representations on the general safety of Rwanda? My lords, we have explained at paragraph 3 of the skeleton argument that why decisions under the MEDP are momentous, both for individuals and the state. And having heard the submissions this morning, this court will not take much persuading of that. But it's important also to note that individuals face being deprived of access to the UK asylum and appellate system, deprived of their liberty, and exposed to forcible removal from the UK. And decision makers must, before deciding whether to do that, assess whether removal to Rwanda will expose them to breaches of fundamental rights, including risks of ill treatment, refoulement, and persecution, all of which would put the UK in breach of its domestic and international obligations. Now, my lords, at paragraph 1 of the skeleton argument, we summarise the 2 basic duties that usually apply in all decision making which affects individuals. The first is to afford an opportunity to influence the decision with representations in advance. The second, which is intended to make that opportunity effective, is to inform individuals of the factors which weigh against their interests. At paragraph 2 of the skeleton, we have set out some key case law which emphasises that where the detriment to an individual from the decision is significant, it enhances the need to afford effective opportunities to influence it. Those cases are, and I don't intend to turn them up because they are so well known, Cooper and Wandsworth concerning whether to demolish a person's house, Doody concerning the length of a custodial sentence for a convicted murderer, and Hirakuma concerning asylum decisions. The principles are so well established, and in any event we'll look at some of these authorities later, that I don't want to turn to the relevant passages. And indeed, the Divisional Court and the Secretary of State both say that these principles are not in dispute. The Divisional Court, at paragraph 383, 3 of the judgment, and the Secretary of State at paragraph 35 of her skeleton argument in this appeal. They accept that an individual exposed to decision making in the MEDP must be given an opportunity to make representations in advance of the decision. But they both deny that that opportunity encompasses the general safety of Rwanda. In my submission, that betrays a fundamental misunderstanding of these authorities. First and foremost, it overlooks the rationale for procedural fairness set out in the Supreme Court in Osborne, reiterated by the Supreme Court in Capon. My Lord, those authorities are cited at paragraph 11 of the skeleton argument alongside an extract from Paul Craig's book, Administrative Law. I want to turn Osborne up, and perhaps I can do that just before we break today at 4:30. It's at Supplementary Authorities 2, that's bundle 28, tab 22, page 925 to 6. This case, as your lordships will all be well aware, concerned parole hearings and the question of whether an oral hearing was required. But importantly, at paragraph 64 onwards, the Supreme Court considered what procedural and preliminary matters concerning procedural fairness at common law, and in particular addressed the purpose of procedural fairness. Paragraph 66, Lord Reid referred to one of the key underlying rationales of procedural fairness, which was, at the end of that paragraph, the utility of the oral procedure in assisting in the resolution of the issues before the decision maker. And he went on at paragraph 67. There is no doubt that one of the virtues of procedurally fair decision making is that it is liable to result in better decisions by ensuring that the decision maker receives all relevant information and that it is properly tested. But he goes on to identify two other important values which are also engaged. At paragraph 68, referring back to Lord Hoffman in AF number 3, at paragraph 68, the first of those other important values was the avoidance of the sense of injustice which the person who is the subject of the decision would otherwise feel. I would prefer to consider first the reason for that sense of injustice, namely that justice is intuitively understood to require a procedure which pays due respect to persons whose rights are significantly affected by decisions taken in the exercise of administrative or judicial functions. Respect entails that such persons ought to be able to participate in the procedure by which the decision is made, provided they have something to say which is relevant to this decision to be taken. And I pause there because both the Divisional Court and the Secretary of State have said that relevance, as the Secretary of State puts it, is not a touchstone to what representations should be made on. And the Divisional Court has said it's a non sequitur for asylum aid to suggest that individuals should be able to make representations on relevant matters. And obviously, there are numerous examples which I'll come to tomorrow showing that that is wrong. My Lord, looking at the time, could I ask you?
Well, I think we know this, the second is in paragraph 71.
Yes.
And then there's a third matter at 72, which won't be relevant, I guess.
No, it's 71. But I do also highlight the passage that is taken from Jeremy Waldron's article.
Yes.
For your Lordship's attention.
Thank you. Good. Well, we will resume at 10:30 tomorrow morning and look forward to hearing the remainder of your submissions. Thank you.
Right.